The sound isn't working. Can you hear me? I can't hear you. Testing, 1, 2, 3, testing.
Hello. You hear me?
I can hear you now.
don't need to look in this.
That's what I do with magic touch.
Thank you, Dale, for your assistance.
Thanks.
Okay, we are ready to go. All right, we've acknowledged that we're going to go ahead and have this live streamed, and both parties are in agreement with that. But at this point in time, the only other thing I would do would be to address one issue. At a prior hearing, I made the statement that I knew Ms. Wallace. Ms. Wallace, I represented your husband, I think, in a divorce action many years ago. Is that correct?
It is correct.
So you would have the right to challenge my hearing this case, and court won't hear cases where there's an issue that involves a possible conflict of interest. If you have any objection to me hearing your case, then I would like for you to state that here on the front end so we can get a special judge to come in and hear it. So.
No, sir, I have no conflict. That was many, many years ago.
Well, the reason I wanted to address that is because Mr. George had, in one of his subsequent pleadings, I think made some mention of the fact that I acknowledged that I know who you were. Of course, you were formerly or may still be the chief of police.
No, sir, I retired.
You retired as the chief of police. All right. Now, Mr. George, then we are ready for you. This is the hearing on number of motions, but essentially what this is for you to demonstrate to the court your claim for adverse possession, because all of your other motions arise from your claim of ownership by adverse possession. So we're going to need to establish that first, but it is your case and I can't help you try your case. You'll have to put on your proof and do what you think is appropriate. So if you're ready you want to make any sort of opening statement, I'm familiar with.
Please, Your Honor. Thank you so much. I really appreciate you stating what you stated. I was not prepared for my actual adverse possession case. I didn't understand what all other motions would be heard. My very first one, you signed off that there was the ex parte was declined, and then I was going to have my quiet title on the December 1st hearing. And when I got here, it was only for ex parte, so I wasn't prepared for that because I was prepared to deliver that then. I had a whole folder for it. So if the courts would please allow us to come back to another day for the actual adverse possession claim, what I would like to present to the courts today, Your Honor, is something called, now I apologize for not knowing the direct legal jargon, but it's something along the lines of the poisonous fruit doctrine.
The fruit of the poisonous tree.
Fruit of
Is
the
that what you're
poisonous
trying to
tree
say?
doctrine, Your Honor.
Now, that is a criminal process. That is a criminal principle, which basically says that if there is an illegal search, then any evidence that is obtained as a result of an illegal search would be the fruit of the poisonous tree, and as a result, it would be excluded. Normally, that has no application in a civil case, which is what we're dealing with.
I understand that normally that would not adhere to such a case. However, I've been arrested over these matters several times and have been dealt great stress and cause by the defendant. And I do not wish her any form of, I don't know what my letters wrote. I don't want her to go to jail. I don't want her to be punished. From what I understand from Ms. Wallace, she was the first lady officer here in Dover, and I respect her for that because I'm a girl dad, Your Honor. However, she lied to the sheriff on November 4th when he came over to my house. She lied again November 12th. She lied to the courts on December, somewhere about December, saying that she had rights to this property. She filed an illegal detainer warrant. She's had me locked up several times, Your Honor. And I do have all the proof on my phone. I requested that I use my phone to be able to present any form of evidence. I also have 3 copies, one for Your Honor, one for Ms. Wallace, and one for myself, which is a new motion for Exhibit XX bundle that proves everything that I'm saying today is very true.
Well, I want to make clear to you, I want to give you an opportunity to present your case, but this case arises from your claim of adverse possession and ownership by adverse possession under a state statute. And that is the issue that is controlling all of the motions that you have filed. All stem or arise from or are connected to your claim of ownership. Your complaints that you're giving today are not a part of that action. They're not a part of what we're supposed to be hearing today. Today is supposed to be solely about whether or not you can establish a legitimate and sustainable claim of adverse possession and ownership of this particular piece of property. So I'm willing to let you put on your proof on that issue. But that issue is what everything else is arising from. All of you have a number of motions. For example, you have all these motions for a stay of immediate stay of eviction, opposition, to a motion for an order. That there are just so many motions. Your motion for relief, your first amended complaint, a motion for relief, your supplemental filing, and a motion for relief, your objections. You filed a letter to the clerk, your amended and supplemental motion for relief, and emergency motion for immediate ruling. And what I'm here today to do is, because of the numerous motions that have been filed, I'm trying to give you an opportunity to establish whether you have any standing to even litigate this issue as a claim for adverse possession and ownership.
Well, Your Honor, you wrote in your judge's order on December 1st that I do have an adverse possession claim. You stated that if you were to be the one to hear it.
A claim is not anything more than a claim. Somebody has a car wreck, they have a claim, but it's to be established whether they have the right to judgment. So you have a claim that you're making. A claim is nothing more than an assertion that you have a right. And the question of whether that claim is legitimate and whether that claim is one that should be granted is an issue that is for a final determination. I'm trying to give you an opportunity because all of the other motions you filed all stem from your claim for adverse possession. If you don't have a sustainable claim for adverse possession and ownership of the property, then you have no right to the property. You have no right to lease the property to your tenant, and therefore all of your other issues would pass because of that fact. So the first and foremost claim is for adverse possession. And are you prepared to litigate that issue today?
I have a folder that I've submitted to the judge. Ms. Wallace has seen it prior, I believe. She can correct me if I'm wrong, please, ma'am. I can try to go off memory from what that folder was. I'd be able to, because it's just the truth. My family's lived at 2138 Old Highway 79 since March 2000. Continuously. Grandparents, uncle, myself, all the way to this day. The neighbor, Miss Marvin Wilson, who said that she had no family. So our family took care of it. My grandparents passed away a year after moving in there. My uncle and father continued taking care of it. My father died. My uncle continued. When he died, I continued. That's where my claim comes. That's been for over 25 years. And in that folder, I've got pictures. I've got documentation.
Excuse me for interrupting.
Yes.
What folder are you referring to?
That with all my exhibits, the one that I requested that if Miss Kim has seen.
Well, are you saying this is a folder that you produced and gave to Miss Wallace?
I've given it to the courts on December 1st, Your Honor.
So is that then something that's contained within the court file?
Yes, sir. It should be. It was documented.
And I have in the court file, there are a number of color-coded tabs. Is that what you're referring to?
I'm referring to the bundles that are exhibits A through F, I believe, with F being all the laws that I tried to quote, because I wasn't familiar with them as far as December 1st goes, being able to recite them. I'm not a lawyer. I'm a normal human. I'm a normal man. I'm a Stewart County man, and I got educated here, so I try to be as prepared as possible.
I have in the court file, but it was apparently filed at the time of the last hearing, there are a number of tabs. They start with full script, exhibit list, lease, tax receipt, photos, keys, my affidavit, LRG Homes.
Yes.
Is that what you're referring to?
Yes, sir. LRG Homes LLC is the registered principal business at 2130 Old Highway 79. Further in showing my adverse possession of being open and hostile as the law is required. It's been over 25 years. I've contacted Miss Mr. Ruben Wyatt, which I've tried to add for the audio files to be accepted. I've contacted our neighbors, I've used ancestry.com. I've looked at Miss Wilson's obituary where it just said the family. I went above and beyond and done my due diligence, Your Honor, in order to find out if Miss Wilson even had family. And then I went into this court system several times, Your Honor, and requested that if there are any probate against Miss Wilson. When I originally filed, they said there was none with Miss Wilson. And then whenever I did some more research, I found out there was one for Miss Marvin Wilson Rimley. So then they added that, which changed another motion that I had to add.
Okay, so that we're clear, I'm going to give you an opportunity to present your proof. You cannot submit a written statement and rely upon that. You can't just file a bundle, as you refer to it, of exhibits. You have to make, under the rule, you're representing yourself. You have to take the stand and testify, and then you can introduce an exhibit. And if it is admissible under the rules of evidence, then that exhibit would be allowed. But there are things that you need to understand. I'm required by law to hold both you and Ms. Wallace to the same standard as if you had an attorney representing you. And because of the fact that we're dealing with the ownership of some real property that has value, I'm required to do it in a way that gives you both an opportunity to be heard. But I'm not going to open it up for you to just basically make a bunch of hearsay statements about things. You're going to have to adhere to the rules of evidence for me to make a ruling if one way or the other. So
May I request from the court, since you did admit to what you should have recused yourself from the thing, may I ask that you do that and appoint a special judge?
and what basis do you have for me to recuse myself from this case?
You've already admitted to knowing Miss Wallace. And you openly stated whenever we first came in here on December 1st, you said, I know Sheriff Gray, how you doing, Miss Wallace? And then you pointed to me and said, and you are? That was very intimidated for me, sir. Your Honor, respectfully. And then when the paperwork said that the TRO had already been denied, and then I was having a hearing for my quiet title claim on December 1st, which you should have those documents, Your Honor, that it was for my actual quiet title. So I came in here with 3 folders prepared, one for Your Honor, one for the defendants, one for myself. But you said that we were only doing the ex parte TRO that day that had already been denied previously. And since that day, I had already been arrested several times. Marcus Jackson had been arrested several times. And now since December 1st, I've continued to be arrested. That's why there's so many motions there, Your Honor. I've been stonewalled by clerks, I have proof. I've been lied to by clerks, I have proof. I've been lied to by county attorneys, I have proof. And I'm prepared to present it in front of a judge that would be fair, Your Honor, respectfully, sir.
All right, well, under Rule 10 of the rules of the Supreme Court, I'm required to make a ruling on your motion to ask that you're asking for me to recuse myself. I'm required to make a ruling on that before we take any further action. So we'll take a short recess.
All rise.
Under Rule 10 of the rules of the Tennessee Supreme Court, court is required to address any motions that's made to recuse or disqualify a judge in a case. I don't believe that I have a conflict in this case, but because of the fact that I'm familiar with Ms. Wallace and have all of the other three judges who preside in this court have already recused themselves because of their personal knowledge of Ms. Wallace, and I had agreed to hear this case despite the fact that I had some prior history, because I believe she would be the one who would be entitled to raise an objection to me hearing this case. But based on Mr. George's objections and the fact that he raises the issue that I'm familiar with Ms. Wallace and he doesn't think he can get a fair hearing, I've reviewed the Canon 2 of the Rule 10 of the rules of the Supreme Court. And out of an abundance of caution, I'm going to recuse myself from this case. Now, because I have recused myself from this case, all four judges are now out of this matter. What that means is that we're going to have to ask for the Supreme Court to designate a special judge. There will be no action taken in this case until such time as that special judge is. So there's nothing, in my opinion, that needs to be filed. Of course, I'm recusing myself, but I'm just telling you that the clerk's office can't do anything for you until the special judge is designated. So I know you have some issues, but I will state that our clerk's office is a professional group of people. They deal with people. My experience has been politely. You may have strong emotions and feelings about the situation, but I would urge you to deal with them professionally, and that you'll get better service from that rather than creating any sort of issue. Based on my having found that I am required to disqualify myself, I will have, based on his objection, continue or adjourning this hearing until such time as a special judge is designated.
Your Honor, can I ask one question?
Yes, ma'am.
He is continuing to collect rent, and I have filed a motion that be to the estate because
Objection, Your Honor.
Be quiet, please. What
Tim
is it?
Care has, has a lien on the estate, and he did not check it now. This is very frustrating and has been a nightmare for our family.
I understand
I'm being
that.
accused of things that are not correct. And I have hardcore documentation, wills, taxes, that some landscaping has been done and mowed by us, electric bills, water.
Mr. George does not own this property. He has a claim for ownership, and that's why, under the circumstances.
But why
Yeah.
should he continue to collect money off something that is not his? That's my only, I would just ask that you consider putting that in a trust or an estate, and so he no longer collects money.
Well, and I think that's a legitimate request, but having recused myself from the case, that'll be up to the special judge to do so. Mr. George, I would simply comment that even though I'm out of the case, I've advised you on more than one occasion, you have a claim for ownership. You don't own the property until a judge rules that you do, and therefore, under the law, it would seem that no one has, if you just have a claim for ownership, you don't have the right to lease the property or collect monies regarding. I'm going to leave that to the special judge who's going to be designated to make that determination. But it may be a situation where Ms. Wallace is correct that those monies, you may be liable for the rent that does it, but that'll be up to the special judge. I have recused myself, so this matter is adjourned.
All rise.